Okay. Hello everyone, and welcome to the CPDP panel to record or not to record COVID-19 body temperature screening and Gdpr'S materials. So in the last year, as we all noticed, uh, different measures have been introduced to tackle the pandemic, and some of them, well, most of them are relevant from the point of view of privacy. And in this panel, we would like to talk and discuss the the connection, the connection between the pandemic and the right to privacy, but not dealing with the mainstream privacy topic of contact tracing apps, but rather focus on body temperature measurement. It is a similarly relevant field as it has to be determined usually in different buildings whether the person who would want to enter the premise represents a threat to the ones inside or not. And from a privacy point of view, this activity, this decision, and data recording is questionable because we need to find an answer on how to deal with this data, both if it is recorded by digital means or through a conventional thermometer. Is the interference with one's privacy is necessary and proportionate? If yes, is the GDPR or the national data protection laws applicable? Again, if the answer is yes, is the information what just has been recorded personal data or qualifies as a special category of data, such as health data? Luckily, at the beginning of the pandemic, the data protection authorities of member states provided assistance to ensure the protection of citizens and their rights and freedoms. These assistance came in different forms and in different depths, but most importantly, the content itself turned out to be very varied, very heterogeneous. So the opinions were often parallel and sometimes even contradicting. And this is the reason why we are having this panel right now, engaging representatives of different sectors, representing different views and understandings of the EU data protection framework. And without further ado, I would like to present our speakers. Sandra Dobler from the International Rail Transport Committee from Switzerland, Nerea Peris-Brines from the European Data Protection Board, Ibolya Tóth from the Hungarian Data Protection Authority, Daniela Galatova from the Pan-European University of Law in Bratislava, and Sara Monteleone from the Italian Data Protection Authority. And I would like to give the floor to our first speaker, Sandra. Please.
So thank you and good morning, everyone. So as you have heard, my name is Sandra Dobler and I am Senior Legal Advisor in charge of passenger traffic and data protection for the CIT. The CIT is the International Rail Transport Committee. So the CIT is an international association of around 200 members, which are railway undertaking and maritime companies coming from Europe, Asia, and also Africa. And the task of the CIT is the implementation of international and EU law related to transport. For this, we develop for our members contractual standards, such as multilateral agreement, as well as general conditions or boilerplate contracts. And in relation to data protection, we have developed for our members a manual on data protection for transport undertakings, which contains in particular examples of clauses and boilerplate contracts. So if we come now to the subject of the day, the question of COVID-19 and more specifically, the question of body temperature. At sector level, when COVID-19 started, UIC, a partner association of the CIT, which is in charge of the technical standardization in the railway sector, created a task force to discuss COVID-19 related matters. And of course, CIT was also on board of this task force to provide its legal support to the activities of this task force. Other associations coming from the public transport and also the airline industry also joined this task force, such as IATA or UITP. In this task force, we discuss issues related to COVID-19 and measures to be implemented in the sector to fight this pandemic. And one of the topics we've been discussing last year was the question of temperature check of passengers. And based on this discussion, UIC also published later a paper on this matter. Because why did we decided to discuss this topic, and why did we have to discuss it in the COVID-19 task force? Because in many countries, carriers were asked to check the temperature of the passengers. In some, it was even the railway undertakings, the carrier, wanting to provide such a check and such a solution for the passengers. And some companies also decided not only to check the passengers, but also the body temperature of their employees. And this, of course, raised big issues. So CIT was asked at that time for its legal opinion on which technical solution to choose to perform this temperature check to be legally compliant. So here, before raising and discussing the question of the legal issues behind it, I would like you to have in mind the technical specificities of the railway sector. Indeed, unlike the airline industry, the railway sector is evolving in an open area. So what do I mean by this? Let's just think about you when you're going and take the train. Well, normally you're just coming from outside, and then you just cross the station and you board the train. In principle, in most of the cases, you won't have to pass any controls, unlike in the airline sector. So some stations receive 100,000 of passengers per day, and even sometimes even million of passengers per day. So in this kind of area, how to implement temperature check in such crowded places. So this was one of the first questions we had to answer in this task force before analyzing the problem from a legal perspective. And well, in stations where there are some gates, like it's the case, for example, in Spain and in Italy, for example, it's easier from a technical perspective to put controls of temperature at the gates with devices, whether analogous or digital. But for other open and bigger stations, there we needed to use other devices which permitted to check several persons at the same time. And one of the solutions which we found was to use thermographic cameras. And if this was available, thermographic cameras linked with artificial intelligence to recognize people with a higher temperature. And those thermographic cameras could be installed on drones, or they were even installed on helmets, like it was the case in China, for example, coupled with facial recognition. But here, when I had to provide then a legal opinion on this, on the compliance of all those different solutions with data protection, well, I was confronted to the multiplicity of answers provided by national authorities. For some, for example, no check were allowed at all, equal if it was with analogous or even with connected solution, connected devices. For others, well, the passenger could be checked, but only with analogous thermometers and not with thermoscanners. And one of the third option presented by some national authorities was to say that it was the passenger which had to do the check by himself. So it was really complicated for us to provide one answer, because in fact, it was more a case-by-case analysis and case-by-case answer that we had to provide depending on the country concerned. And here, I did not even tackle at all the question of who should measure the temperature, but first only the question of what device we should use. Therefore, since I was asked for an opinion and I was asked to provide an answer to this, I based myself, of course, on the precautionary principle, and I was keen to advise to use analog thermometers because they were the ones most admitted by national authorities. But this was not an easy task because we were here in a gray zone, and as mentioned before, analog thermometers were not the solution in some stations. So here we had to admit that also automated solutions such as thermal cameras could be put in place, even if they showed some data protection risk. But for us, those risks were outweighed by the necessity to ensure the security of the passengers, even if some would say that body temperature is not a 100% criteria to determine if a person is infected or not, and that we were, of course, aware of. So yeah, it was unhappily not an easy evaluation I had to do, and we tried our best to take into account the different interests at stake.
Our other speakers, whether they have a question to Sandra. If not, then I would like to have a quick question. Looking into the future, what is your main takeaway from this activity and this advice? Because COVID might be beaten, it might be gone, but body temperature measurement as a safety check, as a safety measurement, might stay with us for any reason in the future.
Sorry, can you repeat the question?
Yeah, just the question is that what is your main takeaway from this exercise or this experience with
Well,
body temperature measurement?
well, I think it was a big challenge for us, not only from a legal perspective, but as said, also from a technical perspective. But this showed us that from a digital perspective, we had to the quality of the passenger. So I think we really had to put on the balance those two interests, and we have seen that through this solution, this was possible. I mean, we have the technical means, we have the possibility, even if it was hard. We succeeded in some ways to put the solution in place and to provide to the passengers, to our passengers, the best experience possible, even in those hard times. And I think this would be the outcome also long term, that we can manage it also from a technical perspective.
Thank you very much. Before we move on to the next presentation, I would just like to notify or comment to the audience that everyone can pose his or her question in the chat box as well, and after the presentations, it will be read as well. So, yeah, for the next presentation would be Naraz.
Thank you very much. If you can put the slides, maybe, please. Okay, thank you very much. So I am Nerea Peris-Briners. I work at the European Data Protection Board, or EDPB. The EDPB is an independent body of the EU with legal personality. It is not an appeal body or a regulatory body, nor does it have enforcement powers on the GDPR. It is composed by the national supervisory authorities and the European Data Protection Supervisor, which is the supervisory authority of the EU institutions. The mission of the EDPB is to ensure the consistent application of the GDPR throughout the EU, and to do so, to do this, it adopts guidelines, consistency opinions, recommendations, etc. And also, it has a very important advisory role to the EU institution, in particular to the Commission. So, with regard to the COVID pandemic, the EDPB had a very quick reaction. In fact, on the 19th of March, the EDPB adopted a statement on the processing of personal data in the context of the COVID pandemic. In this statement, it highlighted that the GDPR does not hinder the measures against the COVID, and that the respect for the GDPR principles and the rights of the data subjects must be observed. Also, in these circumstances, of course, the ADPB recognized that it is possible to apply restrictions on the rights of data subjects according to the GDPR, but these restrictions, as I just said, have to be proportionate, limited to the emergency period, and be adopted in accordance with the GDPR. In this statement, the ADPB also referred to the two main concerns that raised at that time. The first one was the use of mobile location data by governments for contact tracing. In this case, the ADPB stated that the preference was to use anonymous data, and if this was not possible, there should be adequate safeguards to protect the rights of the individuals. With regard to the medical checkups in the employment context, the ADPB recognized that this will very much depend on national legislation, and that in any case, the principles of proportionality and data minimization should be observed. The EDPB also adopted several documents. We actually have 15 documents only related to the COVID pandemic. The EDPB adapted to the circumstances and to the evolving challenges. We adopted guidelines on the processing of data for the purpose of scientific research in the context of the COVID. This was a main topic because of the research efforts to find a vaccine. So in these guidelines, the EDPB analyzed the legal basis for the processing of personal data in this context. In particular, it analyzed the legal basis of consent and also the public interest. With regard to the consent, the EDPB emphasized the need to respect the GDPR requirements, meaning that the consent should be explicit, freely given, informed, specific, and unambiguous. And with regard to the public interest legal basis, this should be established by law. Once again, the EDPB emphasized the importance to respect the data protection principles with special emphasis on transparency, purpose and storage limitation of the data, data minimization, integrity and confidentiality, and also to respect the data subjects' rights. The EDPB also adopted guidelines regarding the development of contact tracing apps, and also it sent a letter to the European Commission on this regard. In these documents, I would like to emphasize that the EDPB underlined that the use of apps should be voluntary. There should not be any disadvantage for non-users of these apps. However, the fact that the use is voluntary doesn't mean that the legal basis for the processing of the data would be consent. The EDPB recognized that maybe public interest would be a more appropriate legal basis as long as there is a basis on national law for the processing. Also, the EDPB emphasized that proximity data is more in line with the data minimization principle than location data, because the goal is not to follow the movements of individuals, but to discover events such as being in contact with positive. Other documents that the EDPB also adopted in this context are, for example, a statement on the restrictions of data subject rights in connection with the state of emergency in some member states. In this statement, the EDPB emphasized again that the protection of personal data must be upheld in all emergency measures. However, there might be, as I said, restrictions to the data subject rights in accordance to Article 23, but these restrictions must be necessary, proportionate to safeguard objectives of public interest, and must respect the essence of the right of data protection, and also these restrictions must be provided by law, be clear and limited in scope and time. Other documents that the EDPB adopted as the challenges evolved are, for example, a statement of the processing of personal data in the context of reopening of borders, because different member states were adopting different kinds of measures when the borders reopened. Last summer, in this statement, the EDPB emphasized the need to respect the data protection principles. It's also called for a common European approach to the measures adopted. And also with regard to the collection of personal data by business owners, for example, in restaurants, the EDPB sent a letter to a member of the European Parliament in which it stated the importance of having a legal basis for this processing, and also to the importance of respecting the data protection principles. So with regard to the guidance on body temperature, as I already said, this is a matter of national competence. It is linked with national legislations on public health, labor laws, even the way in which the right of data protection has been framed in the constitutions of some of the member states. Has recognized this in several documents that what health authorities or employers can do depend very much on the national legislation. And in this, we can see that there was a very early reaction by the national supervisory authorities. Most of them adopted guidelines that addressed the issue of the body temperature checks, and many of the supervisory authorities even address this in the context of the employment relationship. In any case, what it is clear, what the EDPB has made clear through all the documents adopted is the need to preserve the data protection principles even during the times of crisis. So to finalize, the key messages conveyed by the EDPB during this crisis is that the GDPR does not hinder the measures taken in the fight against the COVID pandemic. In fact, the respect of the fundamental right reinforces the measures taken to face the emergency. The respect of the data protection principle is a requirement to reinforce the effectiveness of the data-based initiatives for combating the spread of the COVID-19. There is not a choice to be made with the right to data protection and the protection of health. The outcome of the balancing test is always the respect of the essence of the rights at stake. And as I say, data protection is not an absolute right. Restrictions are envisaged in the GDPR. However, they must be adopted following the requirement of the GDPR, meaning they must be necessary and proportionate. And the measures must be limited in time. So finally, there might be divergences in the measures adopted at the member state level, but this is foreseen the GDPR, and what is the core of it is that the principles of the data protection right are respected. Thank you very much for your attention.
Yes, thank you very much. Again, question to the other speakers, if you have any question, comment to Nerea. If not, then I would like to ask that from the side of the EDPB, were there any harmonizing activities to harmonize the different guidelines and assistance of supervisory authorities? Because there's a big difference in sometimes in the content.
Do you mean referring to the body temperature in particular?
Yes, exactly. Yeah. Or in general.
Okay.
Not in body temperature.
Yeah. We adopted, as I mentioned, we adopted two guidelines on to establish a kind of a harmonized interpretation of the processing of data in the research context and also for the contact tracing apps. It is true that this specific issue of the different guidance on the body check was not addressed by the DPP, but as I said, it is a matter of national legislation. It really depends very much on the national legislation. So of course, the DPP at the DPP level, we say the principles must be respected. Also, how the restrictions, if any, should be adopted. For example, in this matter, we also develop guidelines on the application of the restrictions under Article 23. So at the DPP level, yes, we try to be on top of all the challenges that were coming, and of course, when it is a matter of national legislation, that it really it really depends on the member state, but the principles and the restrictions, etc., should be respected in the same way. And this is what the DPP has tried to convey in all the documents that has adopted.
Thank you very much. Moving on, Daniela, the floor is yours.
Thank you very much. Can you, if I may ask, perfect. So my name is Daniela. I am a student PhD researcher for the Pan-European University of Law in Slovakia. I also work for the European Commission. However, today's presentation will exclusively include information that stems from my PhD research. And I will be trying to present interpretation cross-cutting over the member states and understanding the material scope of the GDPR of each member state when it comes to body temperature measurement. So when the idea of body temperature measurement as a prevention of trying to fight or find infectious persons and identify them, member states pose the questions in various fields. They pose questions in who can measure the body temperature. if it needs to be a medical staff, if it can be employer, if it can be anybody, a guard. Another question was where can we apply the body temperature measurements, whether in employment sphere, in a public space. There was also a question whether it should be established in hospitals, in education, in order to establish other rights like right for education, right for employment. And also the question was how to do it. We had different devices. We had analogous thermometers, infrared thermometers, manual ones. And also the question was whether it can be mandatory given. There were some member states that put it mandatory for the employment. And the question also was whether recording can be done of the measurement data stemming from the body temperature measurement. But the very beginning and the very core question was, is measuring of body temperature processing of personal data under GDPR or not? That's what the member states faced, even in line with the guidelines that were released. I'm sure that we all know the GDPR provisions, but let me have a look a little bit in the visual way. When we ask what the processing is, the Article 2 of GDPR tells us, and that's the material scope in a positive way, is the processing of personal data wholly or partly by automated means, and with the filing in any kind of means. So the question here was whether when we are measuring body temperature, it is partly or automated means. Here, the question was absolutely unanimous in there. But what was raised was whether we fall under personal data or not. And that's when we look into the Article 4 of GDPR, definition of personal data, which says that it's any information relating to an identified or identifiable natural person. Here, the results of interpretation of member states varied quite a bit. For example, Czech Republic by default said that the measurement of a body temperature, the data stemming from the measurement, is not a personal data by default. Then, for example, Belgium, the Netherlands, they had a rather an approach which would say that it depends whether we do recording of this data of body temperature measurement or not. If we do not make any kind of recording based on the body temperature, then basically we do not fall under the GDPR. But if we do a recording afterwards, we would fall under the GDPR. It depends also what kind of device we are using or not. My question here was always that I posed, how could we actually make no other tracing? Because if I measure a body temperature and I have a data stemming from a body temperature, usually there must be someone who is either measuring body temperature or if it's even by automated means, then we will fall under Article 22 of GDPR, then there must be a human intervention in case a data subject is objective. So basically there would be a certain recognition of a data subject anyway. And then another question was raised, whether it's the personal data concerning health or not. Since we do not have any precise definition within the GDPR, we only can have a look in the recital 35, which in my opinion made member states being a little bit differentiated. Because on one hand, that recital says that it's any kind of personal data concerning health with regards to providing healthcare, but then afterwards later, we say that it's any kind of a number or symbol that can be linked to the person, or it's any kind of a data that stems from testing or examination. Here, for example, Cyprus had a very decent approach referring to an ECJ judgment that health, personal data concerning health should be understood in a broad sense. So they by default said that we do fall under the personal data concerning health processing. So what I observed within the research was the different and common approaches. The different approaches was what I already mentioned. If we record or if we don't record. If we record, we do fall under the GDPR. If we don't record, we don't fall under the GDPR. That was, for example, Belgium and Netherlands, as I mentioned. By default, Czech Republic was saying we do do not fall under the GDPR because the data from body temperature measurements are not personal data. But there were also member states that by default defined data from body temperature measurement as personal data. Then the question was also on proportionality, and that would fall under the lawfulness. On what legal grounds would the body temperature be measured? Here, I observed a very big distortion in between member states caused by the national legislation. We have member states that declared emergency state. We have member states like Sweden that they do not even have a possibility of emergency state in these cases. So we have member states that enable in employment law, in labor law, that employers can prevent spreading of pandemics, and even employers can really do the body temperature measurements stemming from law. If not mistaken, Hungary made it even obligatory for employers to make the body temperature measurements. Here my question would be how, and what I observed is the proportionality question. How can we really see the distortion on the EU level, which is of course understandably based on the national legislation, but in one country, for example in Netherlands, the employment sphere, the consent was not enough as legal basis because the relationship between the employer and employee is not balanced, and basically employee would not give a free consent. So that was understood and considered. In, for example, Germany, it was said that the Data Protection Authority made a statement that if the employee gives the consent, then even recording of body temperature measurement can be done. So we see a big distortion in proportionality, in my opinion. Then my question, and also the question of other member states, was whether the body temperature measurement is really sufficiently feasible data. For example, Germany based issue, that we should really look into the principles of minimization and principles of GDPR, because the body temperature measurement is not very feasible and the only criteria that could trace the COVID pandemics. On the other side, what was a common approach was that every member state made it very clear that the privacy is at stake. For example, Belgium was a very nice example of this, that even though there is no recording set up and we would not fall under GDPR, the body temperature measurement is considered to intervene into the privacy of the person, of the data subject. So we need to be very careful about it. And as well, member states also made a statement that the pandemic should not serve as an excuse to actually process personal data without the scope of law, of rule of law. So basically, to sum up, I observed not unified interpretation of application of body temperature when it comes with regards to GDPR. I observed this also in the mobile tracking applications a little bit, even though there was a little bit of bigger development and progress. I observed the privacy was taken into consideration, which I highly appreciated. I saw that the system is very complex due to the national legislations, and I always pose this question with regards to proportionality, and I pose this question also with the mobile tracking applications within my research, whether when a system, in my opinion, is not efficient enough, it cannot be proportionate, in my opinion. And basically, if the body temperature was not the very feasible and the only criteria of tracing the COVID, we could possibly say that it was not very efficient to put the body temperature into practice with all these different changes and different interpretations. And then my question would be how proportionate would it be cross-cutting in the EU? And like that, I would like to thank you very much for your attention, and I'm very happy to answer any questions.
Thank you very much. Is there a question from the speakers? If not, then Daniela, what would you suggest? What should happen next? So a protective measure has been introduced. It has been commented by authorities. but you pointed out the discrepancies, the differences, the ambiguities. How should we continue from here?
Well, can you repeat how should we continue? That was your question.
Yes.
Yes, I think that there was already a progress made when it comes to mobile tracing applications. So there, the approach on member states was a little bit more clear. I think that it would be actually very good to have one common approach when it comes to pandemics. I have a very provocative idea of whether, in case of pandemics, we should fall under a single scheme where we would have any kind of a tool that would prevent member states or enable member states to provide clear and one unified guidance, which of course under the establishment that is currently existing is not possible because we have the competencies of member states on national law. I think what is very important in case of pandemics is rather the educational part and spreading information and trying to unify as much as possible, and that will should come from the member state side for the sake of data subjects and for the sake of citizens of the EU.
Okay, thank you very much. Our next speaker is Iboya.
Can I have my slide? So thank you, István. Good morning, everyone. My name is Iboya Tóth, and I work for the Hungarian Data Protection Authority. And in this presentation, I would like to talk about the Hungarian Dps Guidance concerning certain data processing operations related to body temperature measurement. And this guidance was issued in October 2020, so in the second wave of the pandemic. Actually, in the first wave, we issued one guidance in March of 2020. And in this guidance, we also referring to body temperature measurement. At this time, the point of view of the authority was that a general and mandatory measurement of body temperature with any diagnostic device, so even automatic or non-automated, and not adequate in that pandemic situation. Of course, there can be some exceptional cases, like, for example, for certain jobs like customer experience, who are particularly affected or exposed to the pandemic. And in this case, when additional conditions are met, it is allowed to measure the body temperature. In this case, the legal base could be Article 6.1e or F of the GDPR, whether it's if it is a public body, it's C, or not public body, it's legitimate interest F. And the special conditions in Article 9 too, we would recommend to use point H, which says that this data processing is necessary for the preventive or occupational medicine, and it had to be processed by or the responsibility under the responsibility of a healthcare professional. And in this case, the employer was only entitled to be informed about the results. After the first guidance, the Hungarian government issued some decrees related to the pandemic. It was issued in June 2020 when they declared the healthcare emergency, and after that, in November, they ordered state of emergency, and actually is still in effect. The government has to review it soon. Also, I would like to let you know about another government decree, which was a sector-specific one, because only in institutions of the public education and vocational training, every person, so no matter it was an employee, a pupil, teacher, or other employees who wanted to enter to the building, they had to subject themselves to body temperature measurement. So after this decree, the Hungarian DP received a lot of questions whether since the first guidance we also state that body temperature measurement is still disproportionate or not. I would like to draw your attention to two key points, because in case of the material scope, Hungary is quite specific. because when we promulgated the Convention for the Protection of Individuals with regard to automatic processing of personal data in Strasbourg, we made a declaration that we are going to apply this convention to personal data files which are not processed automatically also. And based on that, as we consider that we reached a level of protection and we did not want to lower it, our National Privacy Act contains a section which says that the substantive provisions of GDPR are applied for the processing not only automatic but for non-automatic means. And for those files which are not form part of the filing system and not intended to be. This means in case of the body temperature measurement that the provisions of GDPR have to be applied to body temperature measurement carried out by the automated or non-automated means. And as I mentioned in one of my slides, this government decree, this sector-specific one, which is only for the institutions of public education and vocational training, we still do not have any national legislation for body temperature measurement in general. But since March and since the first wave, the circumstances changed, and the continuous and significant increase in number of the infected persons made us to make another point of view. And in this second guidance, we stated that during this current phase, body temperature measurement can be in compliance with the principles of GDPR, but only if 4 conditions are met. And those 4 conditions are, it has to be used in the course of allowing entry to the area or the buildings of the controller. It has to be used as a so-called shell protection, so it means that this is a protective measure, and it is used uniformly to anyone and every person who wants to enter the premises of the data controller. It cannot be linked to the identification of the subject of this temperature measurement, expressly relating to this specific purpose, so shell protection, and it cannot involve the recording, the storage and transmission of data. So all these conditions are to met. And as I mentioned that there is no national legislation, I would like to emphasize that the controller is only entitled to permit or refuse entry to the building, and based on these objective criteria that he made beforehand, and of course the controller has to identify the subjects about these criteria. And the identification to this purpose cannot be justified. It means that only statistical data can be collected. For example, how many people were permitted and how many people were refused to enter the buildings. Also, the authority stated that there can be some exceptional cases. For example, if a person's body temperature is generally higher than the average, for example, because of medication or any medical treatment, then the data controllers can accept any kind of documentation issued by doctors which state that this person is allowed to enter to the buildings and to join the community in spite of his elevated body temperature. But of course, this had to be a specific rules of procedure for that, and the data subjects have to be informed about this also. Thank you.
Thank you very much. The question is the same for other speakers. If you have any questions, Liboya. If not, then I would like to ask about the scope of the Hungarian Data Protection Act, that since it extends the applicability to the processing of information which is in general not covered by the GDPR, and it turned out to be quite important in terms of body temperature checks in COVID. Do you think that this should be revisited on a new level, and the scope should be adjusted?
In the EU level, do you mean?
Yes.
Yes, I think the point of view with the Hungarian Data Protection Authority is that the same level of protection have to be provided, and we cannot make any differentiation based on the means and the methods of processing.
Okay, thank you very much. So our last speaker is Sarah.
Okay, thank you, Espanol, the organizer of the CPDP, for the invitation. Good morning, everyone. I would like to say, first of all, that I share most of the point of view of the previous speakers, although it was a little bit difficult to hear everything. And I would like also to present the perspective of the Italian Data Protection Authority. First of all, I would like to stress the fact that was one of the objectives of the Garante, the Italian authority. One of the objectives was to underline the importance of data protection, fundamental rights, as an instrument also to ensure actually the debate on democratic values is carried out. In some way, the example of body temperature measurement can be seen as a basis for a wider discussion on the policy option on the balancing rights, a discussion on the limitation, the restrictions, lawful restriction to the rights. Therefore, a discussion on how strong democracy is and how democratic values can be protected. So, as similar to other speakers, the challenges, the questions, the issues that we received, that we had to face during last year, related exactly to the legitimacy of these checks and their limitations. So questions related to who can do this kind of check, how, in which context, to what extent. The authorities' response is actually included in different documents, in measures of different natures, ranging from statements to opinion to political party to government interventions, guidelines. But the three main aspects that I would like to stress of the Garante's response are basically the reference to the legal framework, of course, the legal ground, the GDPR, the national law, and in particular the several governmental decrees that have been adopted to establish the state of emergency and of course then to extend the state of emergency. The importance of the context, because I think it is also a context-dependent issue, including those of body temperature check. And of course the reference to the safeguards and the core data protection principle that should always be there. So just to give an example, some example of this response of the data protection authorities. First of all, there have been several statements during the year by the Garante, in particular by our former president, Soro. And I would like to here to recall a statement that had been given in March at the outbreak of the pandemic, in which it has been stressed in particular that employers should not collect data of employees in a systematic and generalized manner. This is not so different from what, of course, also my previous speaker said. In this case, the objective was to avoid this kind of autonomous initiative, do-it-yourself initiative that started in the beginning of the pandemic. Another important response has been given during the hearing in front of the Parliament. And I think it deserves to be mentioned, the hearing in May of the President of the Garante. In this occasion, the President wants to stress the importance, especially in this moment of the emergency situation, in this moment when, of course, it is easy to get rid of our rights, to get used to restriction to our rights. In this moment of emergency, the importance of the Parliament role. And the Parliament's role in this moment is actually to assess the proportionality of these measures and restrictions, especially because most of the measures have been adopted at the governmental level. So the Parliament can, of course, have an important role also in that. And the GDPR, the data protection rule, actually can also integrate other rules like labor law or other rules that are applied in this moment. But in particular, the GDPR, which is a transversal application, can also help in try to avoid easy form of limitation, especially for the employees freedom. And so this was in particular here regarding the workplace safety. So this is why it is important the fact that also the data protection of employees are respected. And also because the importance of data protection is that it requires that these measures need to be included in a legal provision. And this legal provision should, of course, define precisely the scope, the purpose, the extent of this derogation. So severe measure can be adopted, but the data protection safeguards need to be there, need to be respected. And also sometimes, like it happened with contact tracing app or devices, privacy impact assessment and prior consultation of the authority could also be necessary. Another kind of response is also the direct contribution of the authority to the governmental decision, governmental measures. One of them is the so-called regulatory protocol on urgent measures for workplace safety. In general, that was related specifically to work environment. In this document that was actually adopted by, signed by the government and the trade union, it was important the debate also with the authority, the data protection authority. The documents say, foresee at least the possibility that the employees are subject to a body temperature check, but at the same time, it not be recorded except when the temperature exceeds the threshold and also when it's necessary to document the deny to access to a workplace. This is for the employees. Different will be the case for occasional visitors or third parties, for instance, if we consider, let's say, a supermarket as a workplace, for instance. But in any case, the important thing is that this document contained already an explicit reference to the data protection rules and safeguards. So this was also recalled in a document that had been adopted also later on. So another kind of example of this response is, of course, including the several facts that the Garant adopted or they are published on the website, several guidelines and vademecum, like the one that I'm showing there. And of course, the facts are also considering the different context and the different areas, schools, airport, or healthcare system, of course, may need different measures. And this example of the vademecum, you can, of course, see the symbol of the thermometer. And in this case, the idea was to give immediately, in particular to those that operate in the touristic and the cultural field, what they can do, what cannot do with the body temperature or with other information. So I would like just to conclude saying that it was important, in particular for the Data Protection Authority in Italy, to stress the fact that the data protection in itself still need to be considered, and especially in this moment of emergence of pandemic, where we consider it as extraordinary, but in some way it's a sort of perennial emergency situation. And the data protection is also there to also consider, to measure, to assess the ability of the government also to manage the pandemic situation. In particular, not to avoid, in order to not to avoid or to have our rights diminished, not to renounce to our freedom. This was an important message, I think. Thank you.
Thank you very much. Is there a question from the other speakers? If not, then I would have one. What was the reception of the guidance and outputs of the authority? Were data controllers compliant and followed your suggestions and guidance, or have you received any complaints from processors or comments from controllers or from anyone?
I must say, from the experience that I have, and also with talking with the other colleagues, deal directly also with questions and issues raised by data controller, they have been usually quite compliant. with the indication that we had. Of course, we have to consider that in some way our intervention also follow the way and the emergency situation. So at the beginning, we received a lot of questions, a lot of claims, and people, citizens or data controller or enterprises or from people from public spaces, they were asking how to act. They were asking if it was lawful or not to intervene in a way or another. And also the facts and the Vademecum also collect these kind of question and issues. By the end of the day, I think most of the cases, they were following the indication. There is, of course, sometimes I think you are, especially for instance, in an area like public order, school, or transport, there are some areas, I think they are overlapping in some way. There is a possibility of different intervention, even from the ministry point of view. And in that case, perhaps there is less clarity, but not from our side, already from the governmental point of view. So there were, of course, the need to have a better indication. What I think is important to stress that since the beginning, I would just to say that, to finish saying that I think what's important, the fact that since the beginning, the Data Protection Authority was involved and had a dialogue with the government on this measure.
Yes, thank you very much. Thank you very much for our speakers for sharing their thoughts. And now we move on to the Q&A part of this panel. And luckily, we have plenty of questions from the audience. And yeah, to start with, why were there so many differences with respect to thermal measuring in the guidance of the DPAs? Would a coordinated approach have worked better, also beyond body temperature? Yes.
If I may, I think that it stems on one hand on the maturity of each member state of understanding the GDPR and taking it seriously or not. I also observed a big difference of how deep some member states could go into interpretation and understanding the GDPR and taking the gravity of the GDPR into consideration as well. I also would say that another point why there were differences was the national legislation. Also the fact that member states are those that face the practical situations. And I think it's almost impossible to provide guidelines on every situation with regards to different national legislation. So I think that was also one reason why. And I think that also because there was no common interpretation of what really the personal data concerning health is, if it's the body temperature is or not, with all the situations. So I think that was the distortion and the difference, the reasons for the differences. And when it comes to coordinated approach, this is exactly what I was saying. I think it would be really great to have an authority, but then we would have to have a centralized authority given the competence to provide guidelines that would be mandatory for all the member states, which is not happening under the system nowadays when the competence is given over to the member states. So yet again, we would fall to what I said before, that the more coordinated approach done in the way that member states are willing to make it coordinated needs to be done. But that's not political than the legal, because legally I cannot.
Yes, thank you. Any other comments on that note? If not, then we look for another question. If we would consider mass temperature screenings via, for example, thermal cameras as being lawful, how should one be transparent towards data subjects and provide information with regard to the temperature screenings? How do you provide information beforehand? And specific question to Sandra, perhaps interesting to hear what you advise to do in practice. For example, mention it on the tickets of passengers.
Thank you for this very interesting question. And well, I would like maybe to answer it by distinguishing the fact to put cameras in station where you don't have only passengers, but you can have also other people, public people just walking around in the station, and people boarding the train and having to go through a check of their temperature to board the train. So when we had this whole discussion in this task force to know if which solution should be implemented, we also had to tackle this issue to know which information and how to provide information to the people who would be who scan through these thermal cameras. And when the question was about putting the cameras in the station to screen the whole station, so all the passengers, all the people walking in the station, here our approach was to say that we should handle it like we do it with CCTV, for example, that there should be a warning before the person enter this place that there are some thermal cameras in the station, and that they are going to be filmed by these cameras and that the data are recorded. And one of the ideas would be also to put a link where people could get more information on this. But our idea was really that the people are informed before entering the station so that they have the choice, if they don't want to get filmed, to not enter the station. So that was about station. Now, more specifically about the question of passengers. And happily, it's not that easy to add or delete information on the ticket. So to provide this information, like we had also the issue about having to wear mask on the train, we were undertaking on that matter, provided the information in different places. For example, if you went to the ticket office, you would have some posters informing you that you have mandatorily to wear a mask on the train. And here for body temperature check, this information, we advise to also add this information if a body temperature had to be done before entering the train. The information was, and we advise it to also put it on the website of the company if people buy their ticket online, and also to provide the information in the general conditions. But from a technical perspective, unhappily, it's too complicated to provide the information on the ticket, because this would mean to make some changes in the content of the ticket, and this required some technical issues and elements that would have taken much more time. So we really work on informing the passenger through the sales places, so that means the ticket offices, but also online, and also, of course, at the station.
Yes, thank you very much. We have questions about biometric data, namely, did you consider the use of thermal tools as processing of biometric data? And following on that, if you did consider thermal tools as processing of biometric data, how did that influence both the proportionality and the risk assessments for the use of these tools?
Maybe I can say something on this. So just as a general remark, at the EDPB, we did not address this specific topic of thermal cameras and whether it's biometric data or not. But what we had to take into account that biometric data, that any image that you get with a camera does not necessarily qualify as biometric data. It needs to fulfill the requirements in Article 9, meaning that it needs to the purpose must be to uniquely identify a natural person, which may be a bit unlikely in this case. In any case, we have to take into account that even if it's not biometric data, if it's a thermal camera where you get the temperature of the person's scan, then we might be in the remit of data concerning health, anyways, which is a sensitive special category of data, and therefore specific safeguards must be put in place.
Thank you.
Sorry, if I can add something.
Yes, please.
Just quickly, I mean, the question on a thermal camera does remind me some years ago when we had the similar discussion with the temperature, the body screening at the airport. And of course, it was important to have a discussion also at the European level, and the Commission, European Commission, I remember, came out with the recommendation on how this body scanning should be designed. So I think it's not so different, the question, and the issues of proportionality, as Nerel also said, whether or not they can be considered personal data, of course, need to be also to have the issues of identifiable data. But at the end of the day, what is important is to respect the core principles. So as for the body scan, there was unlawful to have a complete image and complete picture of the person. That in that case was easy to identify. What was actually agreed is to have a sort of a sagoma, a sort of only external image of the person. So in that case, I think this could be an example of proportionality as well.
Thank you. Any further comment on this topic?
If I can only add, from the observations, there was Slovenia, Spain, and UK mentioning the biometric data processing when it comes to video cameras and CCTVs linked to the body temperatures, but none of them actually enabled. There was no further discussion on that, and so that's just a comment.
Thank you very much. So last question. So it is rather impressive how fast the EDPB and most national authorities reacted to the pandemic in Europe. What were the challenges you were confronted with when you prepared, when you were preparing and drafting the guidance, and what were the lessons learned from this pandemic for the future and your next steps?
I can go first, maybe.
Here can I add something in relation to the Hungarian Dps practice?
We're losing a bit of connection.
Okay, I will be very quick.
The challenge is
Yeah, I think we lost you both. Nerea?
Okay.
Okay, it seems we are losing a bit of connection here, and anyway, we are out of time, so the panel has finished. I would like to thank for all our speakers for sharing our thoughts and for being here, also for the audience for joining this session and posing their very interesting questions. And yeah, would like to wish a nice day, a nice conference to everyone, and goodbye.
Thank you. Goodbye. Thank you. Bye.
Thank you.